I'm with Vrinda Grover, a noted lawyer based here in Delhi, Patricia Mukhim, editor of the Shillong Times based in Shillong, and Yashovardhan Azad, a former top cop as well as a former Central Information Commissioner. And today we're discussing the landmark judgment by the Supreme Court, which has held the sedition law, section 124A of the Indian Penal Code in abeyance. Now, this is a colonial era law, about 190 years only old. And therefore, today's judgment is a significant one. But to explain this and what it means, Vrinda, first of all, you're one of the lawyers for one of the petitioners. In fact, Patricia Mukhim is your petitioner. So congratulations to all of you. But first, explain to us, what does this mean? What does abeyance of Section 124A mean for all of us?
Sure. Thank you, Jyoti. So the petitioners I represented in this challenge to the sedition constitutionality are Patricia Mukhim as well as Anuradha Bhasin of the Kashmir Times. So while as petitioners, we were all urging the court for an early hearing, the Union of India, through the Solicitor General, moved an affidavit before the Supreme Court stating that the government is revisiting and reconsidering the provision, the offense of sedition, section 124A of the Indian Penal Code. And in the affidavit, there was, it alluded that, yes, there are civil liberties concerns. In fact, they said the Prime Minister was cognizant of the same. And they said, therefore, they will be reconsidering. And while they're reconsidering, the Supreme Court should wait. Petitioners' counsels were not agreeable to that. And in fact, requested the court that it should go ahead with hearing because there is ample evidence of its, not only of its misuse, but its utter unconstitutionality. And it is, as you said, an offense which was brought in by the British colonial rulers. And as it exists today, in our view, it has not been tested against the present jurisprudence of the Constitution. The court, however, was of the view that it would like to await if there is some reconsideration. And then there was, of course, the petitioners' counsels urged that then the Supreme Court should at least stay, in a sense, put the present proceedings as well as future arrests under this.
So today, Ms. Grover, so today what happens is that all future, so if the government of, say, Rajasthan or West Bengal or Uttar Pradesh wants to put somebody under arrest, it cannot do so under the...
well, if it does so, it will be in violation of the order. And this is an order in the interregnum. It is an interim order because the constitutional challenge is still before the court. If any government, any police today arrests, lodges an FIR, investigates, or in any manner even detains somebody under the offense of sedition, section 124A IPC, it will be in direct violation of the order passed by the Supreme Court today and will therefore be a contempt of the Supreme Court's order. So it is very important that all state government, central government, police officers are informed right down the line that no arrest can take place insofar as pending cases are concerned.
Ms. Grover, I'm going to come to you regarding that. I'm just getting the views of all the panelists in. Mr. Azad, can I come to you next and ask you, as a former top police official of the Indian Police Service, you've been in service for about 35 years or so now. What do you think this will do, this message from the Supreme Court down the line to police officers around the country? Does it strengthen their belief in the court, in the judiciary, or does this embolden them, or how would you think they would react?
I think it's an extremely important decision, and I welcome it wholeheartedly. And I think every well-meaning police officer would welcome this decision. And let me congratulate our panelist, Vrinda Grover, for doing a great job. In fact, I would say that the Supreme Court should have gone ahead and discussed it nevertheless and given a decision on it, because an outdated concept like sedition in a democracy is really going backward. And the worst part is that in 1898, when it was amended, they brought in words like hatred and contempt. So unless you reword it, anybody can be put under sedition.
No, but Mr. Azad, sorry to interrupt you, but as a former police official, I want to know, when you were a police officer, did cases like this, when did you charge anybody under sedition, or were you did the political class, any of your political masters, did they ask you to do that?
Well, fortunately, I never charged, because I never thought anyone was fit to be put under sedition. Because for me, sedition would only mean something which alludes to an armed rebellion against the state, nothing against the government. In fact, it's the job of the opposition to bring down the government. And fortunately, no political executive or anyone from that did tell me to do anything. So I'm extremely happy. And I was in that period when lawlessness was at extreme. We were 76 batch. In 77, you know what happened. The student movement and all kinds of things happened. And in the early 80s. Once again, let me say that this is an excellent decision. I have always been of the view that the British colonists who did away with this sedition law, we are still having it. It's about time we just junk it.
Patricia Mukhim, you're one of the petitioners. You're a journalist, the editor of the Shillong Times in Meghalaya. My question to you is, why did you go to the Supreme Court? Vrinda Grover is your lawyer, but why did you go to the Supreme Court challenging this law?
Because I value freedom of speech and expression. And increasingly, we were seeing that in Manipur, for instance, several young journalists were being put in jail under the NSA and the very frivolous, charges. And for me, I think freedom of speech is the ultimate goal of a democracy. In the past, Vrinda had represented me in a case where I was accused of creating communal disharmony under sections 500 and 5051A or something to that effect.
3A.
And so, and just because I was trying to get the government to act on cases of attacks on non-tribals, which were quite frequent in Meghalaya. I was just calling out to the government to please do something and let not, another case be filed against unknown miscreants, which is generally the rule. We've had communal conflicts since 1979, and not a single person has been arrested for bloodshed, for lynching. So it was a great concern for me. And I put that up as a Facebook post, which was construed as an attempt to create civil disturbance, communal disharmony, disaffection, and so on. We fought that case successfully, thanks to Vrinda. And therefore, I thought, I feel that sections of the law, like the Armed Forces Special Powers Act, like the sedition law, they have no place in a modern democracy, in a country that calls itself free and democratic. So that's why I thought I should fight this out.
Okay. Vrinda, Patricia has referred to these various sections. Now, can you explain to us the difference between the sedition law, under which Sharjeel Imam, a former student of the Jawaharlal Nehru University, he has already applied for bail, actually, within the hour of the Supreme Court giving its judgment. Umar Khalid, another student, but he has been charged under the UAPA, the Unlawful Activities Prevention Act. Siddiq Kapan, he has also been charged under the UAPA. In fact, this poor journalist from Kerala has been in jail for the last year, for more than a year in the Meerut jail. There are so many others, hundreds of others who've been charged with contempt or criminal conspiracy. What is the difference between, say, sedition and UAPA and the others?
The offense of sedition, and to my knowledge, Umar Khalid, Sharjeel, all of them are also facing charges under, they've been accused under UAP, and therefore the bail becomes all the more difficult. Sedition is about speaking, about visible representation. It is about words. It's about writings. When words or writings in any way, as the offense says, it either excites hatred or contempt or disaffection. Now that term disaffection is extremely problematic. Why do I, as a citizen of a free country, and I am a rights-holding citizen, in the Constitution, the citizen is at the center. the entire scheme of the Constitution is to curb and the power of the state. What sedition does is that it puts restraints on our freedoms, particularly freedom of the press. And other journalists are therefore repeatedly targeted, both in Kashmir here, and as you mentioned, some examples of Siddiq Kapan and others. So what this says is, if you have disaffection towards the state, towards the government established by law, not even the state. Now, we've had judgments of 1962, the Kedarnath judgment and the Vinod Dua judgment of 2021, where the Supreme Court has repeatedly reiterated that criticism, prescient criticism, any kind of comment is not sedition until and unless there is a proximate and direct relationship or a tendency to incite violence. Not one of the illustrations or cases before us, and we've seen the NCRB data shows a huge jump from 2011 to now, 160% jump in cases lodged under sedition. So sedition per se is, I can make a remark just now, which maybe somebody sitting in government does not like. I may have a view which disagrees with the view of the government.
Right.
That does not amount to sedition, because then my other rights, and we know our right to life includes my other freedoms, apart from the freedoms being there under Article 19. So those freedoms have been center stage.
Okay.
And the other difference here is, so laws like the Unlawful Activities Prevention Act, etc., there will have to be some kind of act. The act cannot simply be an act of writing or words. Or the act will have to be somewhere where I have, got arms, ammunition, got a mob together, done something. Only then will UAPA come into being. Sedition has been weaponized against journalists, activists, and political opponents by all governments.
Okay. Mr. Azad, this difference between UAPA and sedition, now Vrinda has explained some of it, but she says that if you're only making a comment or a speech, then you can be charged with sedition, but otherwise UAPA would necessarily mean that you are involved in some sort of activities within quotes. Now, Sharjeel Imam, I just want to bring this example to you. He has been accused under sedition of making inflammatory speeches at Jamia Millia University, at the Jamia area in New Delhi in December 2019 in an anti-CAA protest, as well as at the Aligarh Muslim University in January 2020, again at an anti-CAA protest. Now, my question to you is that he may be let off under sedition, he may be granted bail under sedition, but he can be brought back and put back into jail under UAPA or some other act, isn't it? So basically the question of making the sedition law null and void is very much present.
No, the sedition, as Mrs. Grover has rightly explained, it's too problematic. The wording itself is such that anybody can be held under sedition. Anybody speaking against the government can be held against sedition. Now, citing how Hanuman Chalisa can be put under sedition, that really, my mind fails to, even comprehend that kind of
thing. This is the Maharashtra police that put Navneet Rana and her husband just 2 days ago.
So what I'm saying is,
charged them under sedition.
Yes. This is the ridiculous extreme to which we are going. So the problem is, how are these being instituted? They are being instituted taking advantage of the law itself. So either you junk it out or you give such clear guidelines. Even the Kedarnath Singh guidelines have not worked because it was clearly stated that just a statement does not mean anything. Today, the tweets are going to be weaponized now. So now our next point is about UAPA. I'm certainly against those people who make statements like, is desh ke tukde tukde. That is something which I will not accept. But anything else, which is a kind of criticism of the government, criticism of the policies, speaking something in a sloganeering manner, you cannot use even UAPA. UAPA is something, yes, it is against the unity and sovereignty, integrity and things like that. But how it constitutes an attack, does it actually, is it an incitement to violence? Is it taking up arms? Does it create some kind of foment a kind of a rebellion within the society? Does it lead to any kind of an action? Otherwise, statements per se, they don't mean anything. Even if 5 people are not reacting to a particular statement and you hold up some guy, that is unfair. So I think the time has come not only to take a decision about sedition, but also take very tough decisions about instituting UAPA. And you know what is happening? Even the poor policeman is being stretched to that extent where the actual things he's supposed to do, he's not able to do. He's not able to patrol the streets. He's not able to maintain order. He's not able to maintain traffic. So I'm taking from a purely practical point of view, you're unnecessarily stretching the police.
Okay, so Patricia Mukhim, explain to me as a journalist, now, do you feel that you have to be much more careful about you say, otherwise you might be slapped with one charge or the other, sedition or UAPA? And give me some examples of yourself or your colleagues. Kishore, for example, the activist who was put inside jail for sedition. Talk to me a little bit about what's happening in your part of the world.
See, in Meghalaya, I must admit it's not as bad as it is in Manipur. And we know for a fact that sedition and other charges are, there are many more cases in the BJP-ruled states. I hate to say this, but that's the fact. Especially the Chief Minister of Manipur, Biren Singh, is very intolerant of any kind of criticism against his government, against himself, even though there was a missive from the Directorate of Information and Public Relations on something. And people started tweeting about that. Even that was taken an affront. He took it as an affront and filed charges against some journalists. Then they pointed out to him that it was the DIPR that gave this news. So I think there's a sort of a feeling that journalists are up against the government. I don't understand why, because a political party and a ruling government are not infallible. And it is the media's prime duty to point out these anomalies because we represent the voiceless, the unrepresented, those who can't speak for themselves. Now, if we start self-regulating ourselves because the sword of Damocles is hanging over us all the time, then what kind of media freedom do we have left?
Do you feel that you're self-regulating yourself much more?
Yeah, I think I'm becoming a little wary of the words used, although I shouldn't be, but because you are in an institution that's, it's a small institution, the Shillong Times, we cannot afford to be paying lawyers' fees all the time because as it is, we have several defamation cases being fought in the local courts, in the High Court. So the management also does feel that we should be a bit more sort of, circumspect in our reports, which we are, of course. Even the case that of my Facebook post, it was because Vrinda and her team took it up pro bono because the management will not pay for that. It's considered as my personal views. So I think that the media now in this country, there are very few media houses anyway that are really free to voice the concerns of the public.
I know you're right about that, and I think we can talk about the media. But let me come to you, Mr. Azad. I want to pick up on what Patricia said about BJP-ruled governments perhaps being more insecure. But recently it was the Maharashtra government or the Maharashtra police which slapped the sedition case against the Member of Parliament Navneet Rana and her husband. So, in a sense, can I ask you why the police of various states are being increasingly used as an instrument by their respective governments to slap these cases against people whose opinions they don't like, whose comments they don't, they are against? So the police has become a favorite instrument of every state government.
See, it's a class of politicians we are talking about who have changed. It's the state governments across the board are the same. In fact, I have been maintaining in my debates all over that in the Ram Navami processions, all the states failed. The 9 states failed. One state cannot claim that, because of PFI, we can't do anything, or the other state can't claim that it's because of the Hindu Vahini, we can't do anything. It's the job of the state to control. But the point is, the kind of dissent which we are having today was there earlier too. And let me tell you another thing. The police was being used as a political instrument even earlier. It's just that it's brought to the fore because there are some brave lawyers like Vrinda, Patricia Mukhim, who are the writers, that these things are coming to the fore, and I'm extremely happy about it. This shows, I have always maintained another thing, that politics in this country revolves around right from the grassroots institutions, from the panchayat institutions to the thanas to the other things. And let me tell you another thing. The rise and growth of some of the biggest politicians is because of the police activity or the arrest which has been effected. So some of them actively encourage it. And I'll tell you another thing. What is happening today is that the battle for police control has become so intense that they perhaps realize that this is the only instrument of the change to be effected by themselves in the manner in which they want. And that is why the police is being used. Now, what is the antidote? The antidote is a very strong leadership. But if the strong leadership is put aside or superseded, you can't do anything about it. And yet I'm telling you, there are 30% strong, committed men in the IPS cadre who are willing to stand up, but they are put by the wayside. And that's why there needs to be a national debate. And I wish even Supreme Court lawyers like Vrinda Grover, take it up, that what should we do about police autonomy? Because even the Chief Justice of India has said that to make police more accountable to the public, there has to be some distance between the police and the political executive.
Okay, so Vrinda, let me come back to you and ask you the two questions that have been bothering me. The first is that, we talked about Sharjeel Imam, but what happened? So are you saying then, or is this the message of the Supreme Court from the judgment today, that everybody of the 1,300 cases or 13,000 cases, I think, in the last 10 years, let me just give you this figure, in the last 10 years between 2010 and 2021, 13,306 people have been slapped with sedition. So are you saying then that each one of these people can now come before their respective state, the courts in their governments, in their states, and ask for bail? Is that correct?
So two things here. This is not a judgment, it's an order.
Okay, sorry about that.
Yeah. To be decided. So what the court has said, many out of those 13,000, many are already on bail. And for instance, I don't want to discuss any specific case because many of them are being heard by the courts as we speak. But you may be on bail in a sedition FIR, but you may be in jail because of a UAPA case.
Right.
But the court is speaking only towards the sedition matter. There are many who were arrested only under sedition, particularly activists, journalists, students. For instance, there could be a cartoon, there could be a tweet, and it's the displeasure, actually. The threshold has fallen to displeasure. If there is displeasure of the person who's being ridiculed, you could well be facing sedition. If that is the case, hopefully you're on bail. If you're not, now the court has said, in terms of this order, that bail should be granted. If the trial has commenced and is only under sedition, that trial that prosecution will halt for now, till the Supreme Court gives further orders.
Okay.
For instance, in the Bhima Koregaon case, it is not just sedition, it is also UAPA and other provisions.
Right.
Only the sedition charge prosecution is not to proceed. The rest of the matter, in any of the cases, the court is not stopping those, only vis-a-vis sedition. It has asked for that to be halted.
So they can be let off on sedition, but they can be kept
let off. The prosecution will not take place. Letting off is a judicial, after trial and after scrutiny of evidence, somebody.
No, they can be given bail under sedition.
And the case will not be prosecuted. When they are prosecuted in the trial, it will not be on charges of sedition for now.
But since they have also been charged under UAPA,
that will continue.
So they remain inside the jail. That
depends what your case is. It depends what your case is. The court is only, because before the court is only the sedition challenge. UAPA was not challenged in this set of petitions.
Okay. Right. Mr. Azad, one quick question to you. Today, the Law Minister, Kiran Rijiju, said that the government welcomes this order. Of course, it's not a final judgment. We know that the court is going to meet again in July, and then they're going to take this matter up again. But Mr. Rijiju made an interesting remark. He said, we know there is a Lakshman Rekha, and he alludes to the division of powers between the executive, the judiciary, and the legislature. Now, what do you think he's trying to say? Is he saying that the judiciary is overstepping its mark, its authority, its jurisdiction?
Well, I'm surprised because the center itself first said that the sedition law is not bad. It's a manner of how we are using it. And in any case, the Supreme Court has given guidelines in the Kedarnath Singh judgment. So they did not admit that it is at least being misused. And that is one of the greatest reasons why the petitions have gone up. Okay. The Supreme Court would have taken the constitutionality of it. And I'm sure, eminent lawyers like Vrinda would have taken the matter that does this sedition law even have relevance now in this country, given the, freedom of speech and things like that. So what Kiran Rijiju must be alluding to is that, yes, there is a division between the powers of division between the legislature and the court. And we'll see when it comes, because we are taking a view ourselves, because they are taking a view themselves on what to do with it and give their own opinion. And that's why I thought the Supreme Court shouldn't have waited for the government's here. It was a clear thing to decide on whether we should have sedition law or not.
Ms. Grover, the question to you, when Tushar Mehta, the Solicitor General, comes to the court, and yesterday and again then today, which is Tuesday and then Wednesday again, and he says that, and when the court has asked him that what is the center planning to do, he says the center wants to review this law, and then he says the superintendent of police, like it happened in the Vinod Dua judgment, and unfortunately, our good friend Vinod Dua is no more. He passed away from COVID last year. Now, he talks about, this is the Solicitor General talks about the fact that a superintendent of police can give in writing why X person has been arrested under sedition.
It doesn't mean anything.
Why doesn't it mean anything, Mr. Azad?
I'm glad Mr. Azad is answering this.
Yeah, can I ask Mr. Azad to answer this, please?
The way the cases are being instituted, what are the reasons? What is the reason for Bagga's arrest? Bagga was arrested at 153A, and I'm sure Ms. Grover is already laughing. 505. I mean, it's ridiculous. So, what
is ridiculous? Explain to us what is ridiculous.
If somebody has tweeted, what did Bagga tweet? He tweeted about that, Chief Minister, I will not allow you to live more or something like that. So somebody in Mohali got so charged up with his tweet, and then Punjab police acted with great alacrity and moved into Delhi to arrest him. And then they arrested him and did not take the transit remand, which is mandatory. And then they were cruising along the highway till they were blocked by another illegal order of kidnapping. So what I'm saying is, what kind of reasoning can you give for this? Tell me. What kind of reasoning can you give for Navneet Rana, who could have only been booked for public nuisance at the best? And these two tweets at best could have been charged under defamation. That also personally. So what I'm saying is ridiculous. I mean, when you are arresting, what kind of way can you, Mewani's case can be, even a Barpeta in Assam? There is just no case.
Ms. Grover?
I think very rightly Mr. Azad has pointed out. I just want to, so Dignesh Mewani's case is definitely to the point where, again, what is he being arrested for? It's repeatedly simply criticism, yes, which a political opponent will do, and actually any independent-minded citizen must do.
That's the job.
That is why we live in a democracy, or we at least, there's no point constantly flaunting and saying we are the largest democracy when even a slight tweet seems to cause such a huddle over here. Also, what I want to add about the superintendent of police, there's this peculiar, I don't know what Mr. Azad's view on this is, there's a peculiar belief in our system, and I personally put it down to somewhere the casteism lurking within our understanding, that the man on the top is going to take the correct and right decision, and it's these lower underling cops who are actually not, they're ignorant of the law, and so they are arresting. Arrests under sedition are not made out of ignorance. They are made through instruction, which is malified. And that this malified directives are coming from the top.
Yes.
And they're flowing down that line. It is not that SI who is going to go at the sub-inspector who's arresting, or the SHO who's supervising, who's necessarily has some animus towards this person. The person on the top is sanctioning this because the police and the law have today become weapons in the arsenal of every government. And therefore, we have these examples of this is the way power is being used today.
Right.
So how will the superintendent of police necessarily take a contrary view? This is a charade, and I'm so happy that the court did not pay any heed to it. And yes, agreed to say, okay, we will defer. But as Mr. Azad said, we felt that the court should hear any judicial review, constitutionality of any provision, this or even a new provision if drafted by this government,
Right.
will be challenged and will be tested. And the only forum that will decide on the constitutionality is a constitutional court, either the High Court or the Supreme Court.
But you
I
know,
also wish to say here, I really think vocabulary of political leaders needs to change. I think the phrase Lakshman Rekha needs to be junked along with sedition. This Lakshman Rekha is a misogynist, patriarchal term. We do not need Lakshman Rekhas. The Constitution sets the red line, and the state transgresses that red line all the time.
absolutely the last question to you, Patricia. From today, you've been a petitioner in this, taking this matter forward. For you personally, and for your colleagues, for journalists, and for other people, what is the moral of the story, and what do you take back from the Supreme Court order?
So I feel very, there's a sort of there's a sense of achievement that we've made some progress. Of course, we still have a long way to go, but these are small successes that, we can build on and hope that many more people will join as petitioners, because there is a certain hesitance to even become a petitioner in these sort of cases. So I would hope that many more people would come forward and petition the Supreme Court. Maybe if we had millions of petitioners, I think the Supreme Court will have no alternative but to take the right point. As Mr. Azad said, we are still wondering why the Supreme Court had to wait for the government to keep giving its whatever.
But I think that Chief Justice Ramana and Justices Suryakant and Himakoli have done an amazing job after 190 years, which is quite remarkable. Because
Yes.
the sedition law in the UK, which presumably is the country that imposed this law in India when it was still, it was not in fact, not even under the crown at the time, but that finally that this law is being examined, and hopefully by the center as well. But this has been quite an unprecedented day. And I would like to thank all of you, my panelists, Vrinda, Yashovardhan Azad, and not least Petitioner Patricia Mukhim, for this wonderful discussion on the aspects of the sedition law. Thank you all so much for joining me on the Print Debates.
Thank you.
Thank you.